Welcome to You and the Law. My name is Steve Cilente.
And I'm Bob Lally.
We hope to do in our program is to talk about the law, how it affects you, and in our daily lives. There's so much that is out there that people don't realize is governed by the law. Now, since our last program, Bob, there was a question about what is tort law?
That is a very good question. Let me just talk about that for just a minute or two. What tort actually means is tort means a twisted act. It's a wrong done to somebody. And what the civil justice system does is gives an opportunity to correct that wrong and be compensated for that. But it's a wrong where somebody was negligent. For example, you drive a car, you're held to a certain standard of care, you can't cross the line, and if you cross the line, that would be negligent, that type of thing. But basically, a tort is where somebody has been injured in a civil setting, and it's a right of remedy to be compensated for that loss. And quite frankly, one of the reasons we have that type of system, and it works very well, is if we didn't have a system like that, people would go around bopping each other on the head because they'd be mad at each other. They couldn't get compensated. So, that's basically what a tort is.
But it doesn't require a physical injury, correct? It could also involve an emotional injury, a psychological injury, or an injury to a business. In other words, I do something that keeps people out of your business. Paint some god-awful symbol on the front door that keeps drives your customers away. So it really is beyond, it's not necessarily a physical injury to you as a person.
Right, absolutely true. Businesses and business entities, and there's special rules and regulations, but corporations are basically treated like persons under the law. And they could have their businesses damaged and something like. And it's interesting that you talk about psychological injuries, because yes, absolutely, there are psychological injuries. Those are very sometimes special type of cases because they involve special type of experts, and you open up the can, so to speak, as to your background if you bring one of those. But and there's certain circumstances where relatives can recover, and sometimes there has to be some type of physical manifestation of that, and sometimes not. But there's very specialized rules about that.
When you talked about civil law and you mentioned driving on the right side or the wrong side of the road, causing an injury, certainly someone can bring a lawsuit based upon whatever your act was, but most often, we're not seeing the civil action as much as we'll see criminal law step in, whether it's an infraction, felony, misdemeanor. So really there is some overlap. You may have done a civil wrong, but there may have been a criminal act that resulted in the civil wrong, and somebody can sue you. But most often, Bob, isn't it fair to say that most people that we run across, certainly, they've run afoul of the law somewhere, whether intentionally or unintentionally, and we see them in the criminal law context, and they may not think it's a criminal act, like a DUI. A lot of people don't realize that is a criminal act, but it is criminal law. Getting a speeding ticket really is criminal law, but people don't think of it as such. But that's just probably where most people would have an interaction with the court, is in some criminal law context. So what is criminal law?
Well, what is criminal law? That's a very good question, and I think it could go for more than our show here, but you're absolutely right. There is a big overlap. Criminal law covers pretty much everything you do, and one thing you mentioned is if you didn't know about something, you could still be criminally liable for it, because in most of the cases, ignorance is not a defense.
That's interesting, because we've heard that so often, that ignorance is not a defense or is no excuse. We actually have in California what are called maxims of the law. And that actually is codified. In other words, it's in a code somewhere. It's in the civil code. Starting for those that really want to go do some homework, section 3509, and it runs through 3508. And there are interesting things in there, such as no one should suffer by the act of another. He who takes the benefit must bear the burden. These are maxims of the law that kind of give guidance, overall guidance about what the law is. Now, certainly the one we hear most often in criminal law is regarding ignorance of the law is no excuse. I didn't know I shouldn't drive on both sides of the road when there's a double yellow line. But we heard, as I mentioned, infraction, misdemeanor, felonies. What are they?
Oh, they're different types of cases. Infractions, I think, is what most people are going to encounter. And you know, they can be for many different types of offenses. An infraction could be a traffic ticket. An infraction could be throwing paper on a public beach. And interestingly enough, maybe some drug-related possibilities with marijuana might be an infraction even now, you know, so.
That's an area that's continually changing, and a program in and of itself.
True.
We talk about marijuana.
I just want to say that infractions can cover the gambit. You can get an infraction and just not know it.
An infraction, for those that don't know, and most of us don't, or most people don't, you're not entitled to a jury trial. That's where it is different from a felony or a misdemeanor. It's usually a traffic citation for going too fast or some other minor traffic or other violation of law. But you still certainly have a right to a court trial. Now, they're handled a little bit differently than other types of crimes in that you can actually ask for a trial by declaration. And where it's unique is you can say, I want a trial by declaration, and literally you write out under the penalty of perjury why you don't think you should have got this, let's say, a speeding ticket. I wasn't driving too fast. My speedometer was off, whatever it was. And you submit that to the court, and they will look at it as if you were testifying. And the officer does likewise. Now, where it's unique, and you can look at the rules of court for the individual county that you're in, if you don't like the decision, you can then ask for a court trial on the same facts. Now, obviously, if you win, that's the end of the case. But there is no jury trial for an infraction. But otherwise, the rights are pretty much the same as a misdemeanor. Now, what's the maximum that could happen for misdemeanor?
Well, misdemeanors they're 1 year in jail or a $1,000 fine. That's basically the limit. Can I comment on one thing about a live court trial for just a second?
Sure.
Okay. It's kind of, there are advantages and disadvantages to going to the live. One thing is, and I got to tell you, it happened to me some time ago. I got a traffic ticket, and I went and wanted my hearing. I went, and the officer didn't show up. So I of course, you know, I won that. It was dismissed. And another type of situation is some of the judges, and particularly up in the rural areas, they try to work with the people and solve your problem. You might be a commercial truck driver, and there might be a violation of a certain thing that would affect your license. So a judge might find a situation where they find a county ordinance that applies that's not going to have that effect. So, I mean, there are reasons to have a live hearing, but let's talk about misdemeanors.
Okay, you're right. Misdemeanor, the maximum penalty is usually 1 year in the county jail. Some crimes are different. They may be 90 days, 6 months, county jail, a fine, and or both. Both meaning a fine and the county jail. Additionally, there can be probation attached. Now, actually, as far as I know, probation can attach to infraction, but it'll be court probation only, usually consisting of obey all laws and certainly pay your fines on time. But with a misdemeanor, you can be on probation, depending on the type of situation, for 3 to 5 years. Okay. And what does that mean? It means that instead of the court, giving you 30 days in jail, they agree that you'll do no time or 1 or 2 days on a work program where you actually do what I call involuntary work someplace, and you're on probation for 3 to 5 years. Now, you don't have to accept that probation, but understand, if you don't accept it, the consequences are probably going to be harsher.
That's true. Now, what's the difference between formal and informal probation?
When I said court probation, I meant is also referred to as informal probation. That is where nothing happens, you're not reporting to anybody, but if you violate a new law and it goes across the court's desk, one of the court clerks finds it, they can actually violate you while you're on probation for the original charge, give you additional consequences on that charge, plus the consequences on the new case. So, yes, there are some very significant things regarding probation. And when we do a program on strictly DUIs, there's a new law that just came into effect in this past year that if you're on probation for a DUI and you refuse to take a test, a breath test, blood test, urine test, whichever, it's an automatic 1 year suspension.
Automatic.
If you have any blood in your, or alcohol in your system, period. Not if you're over the legal limit. If you have any alcohol in your system, it can result in a 1 year suspension. But that's new as of this year. And that's one of the things that's real hard about the law sometimes, is keeping up on all of the changes. So we've got infractions, we've got misdemeanors for which you could serve some time in jail. You can't go to jail on an infraction, it's fine only. We talked about probation. Then we go up in the scale, and that is felonies.
Felonies, yes.
And how do they differ?
They differ quite a bit. They're more than 1 year, of course, they're more than 1,000, and usually involve complicated sentencing schemes and triads. The lowest a felony could be is 16, 2, or 3. And
what does 16, 2, or 3 mean?
Okay, that means the middle term. You take a specific offense, and any term could apply. You have 3 terms: the lower, the mid, and the upper. The lower, the middle, and the upper. That would be 16, 2, and 3, 2 being the mid. And the judge starts at the mid.
Let me stop you there.
Okay.
One of the problems that we have lawyer to lawyer is we talk sometimes in acronyms, or we have a special language. And everybody out there, that irregardless, bad word, regardless of what employment you have, you've got shortcut language. 16, 2, or 3, that means the maximum penalty may be 16 months in state prison, 2 years in state prison, or 3 years. That's the triad. Generally, the court must always start in the middle, 2 years. Now, some crimes, of course, are much higher than 16 months, 2 years, or 3 years, but the court starts in the middle. If there are mitigating circumstances, something that says your crime really isn't as bad as the average person, then you may get 16 months. If it's aggravated, then you can get what we refer to as the upper term, or 3 years. Now, the triads do vary from one felony to the next, correct?
Greatly, and that's a whole show in and of itself. Particularly, everybody knows about the 3 strikes, but we won't get into that. But whether it's a misdemeanor or a felony, Steve, what's the first court appearance? When somebody goes to court, what's the first thing that's going to happen to them?
Actually, in any of the three, infraction, misdemeanor, or felonies, the very first thing that happens is when you go to court, it's called an arraignment. That's where the judge tells you what the charges are, usually reads them off to you. Also, rather than now doing it open court like they used to, they hand you a piece of paper when you first walk in a courtroom that lists all of your rights, usually in very small print, and most people don't read it, they just sign it, hand it back, and the judge holds up a piece of paper and says, did you read and understand this? And the person says yes, and I can guarantee that most of them haven't read it, and if they did, they probably don't understand it. But that first court appearance is primarily to advise you what your rights are, advise you what in many cases, what the maximum consequences are, tell you what the charges are, and determine whether or not you want a lawyer.
Now, in misdemeanor cases, it's true that lawyers can make an appearance for the clients. That can happen in special circumstances in felony cases, but in misdemeanor cases, that's more common, isn't it?
Whether an infraction or misdemeanor, there is a provision in the California law that says that a lawyer can appear without their client. I've got many cases where I've handled the entire case. The client has never seen the inside of the courtroom. That includes through the plea process, through the punishment, the judgment, as we call the process. The lawyer handles it all. Not so in a felony. There are limited cases or situations where in a felony where the client does not have to be present, but that isn't very rare. The client normally has to be at each and every court appearance if it's a felony. But while you've got the arraignment, the three, the infraction, the misdemeanor, and the felony are all the same in that regard. We know that in infraction you're not entitled to a jury trial, but you are in a misdemeanor and a felony. For the most part, they're pretty much the same. But in a felony, you've got an intermediate step, and they call that the preliminary hearing. Okay.
Right. And that comes, there's a time limit within the arraignment. When somebody comes into court and they're arraigned, one of the first things they're asked if they want a lawyer. And under the Constitution, you have a right to a lawyer if you can't afford one. And generally speaking, it's pretty good to ask for a lawyer, I would think. Wouldn't you say so?
Absolutely. Now, one of the things I failed to mention is an infraction, you're not entitled to a lawyer.
That's true.
At public cost. If you want to go hire a lawyer, that's fine. What most times you'll see, if you go into traffic court, there's not even a prosecutor there. There's the officer who's going to testify that you did some wrong. You have a right to testify. You have a right to bring your own witnesses to testify in your behalf. But unless you hire a lawyer in an infraction, you're not going to get one at public cost. Misdemeanors, yes. Felonies, absolutely. But then we've got this preliminary hearing. Now, the preliminary hearing, Bob and you and I had talked about it before, and it has a historical basis. But in California, it's actually in our state constitution. And it's not something we learn in law school, by the way.
No, it's not. It's not. And quite frankly, that was a surprise to me when you mentioned it earlier today.
For those that may be interested, we had mentioned during our, one of the other shows that findlaw.com is one of the websites we'll refer to periodically. That's a place to look up things. But if you go on the internet and you put in California Constitution and you look under Article 1, Section 14, well, there it is. It says that if it's a felony case, you're entitled to a preliminary hearing. It even tells you what it's supposed to be about. Now, a lot of people, when they think about preliminary hearing, it looks like a trial. There's testimony. It's got something called hearsay that's admissible there, that's not admissible in trial. What is the whole purpose behind a preliminary hearing?
Oh, well, a preliminary hearing was originally designed kind of for the benefit of the people. It was to weed out so that it would not be a hardship for a person to have a full-blown trial in a criminal case if there wasn't at least a reasonable suspicion that there was a crime committed, and that was the person that committed that crime. And it's a lower standard. It's a reasonable suspicion at that point, not beyond a reasonable doubt. But you can, a lot of things shake out at those preliminary hearings, and I've actually had cases that were dismissed, and I know you have too at the preliminary hearings. Or if they were overcharged to some extent by the district attorney, the offenses are reduced sometimes.
They can also be added to.
Yes.
The preliminary hearing is a unique animal and unique to felonies. And it's kind of difficult for people to understand, well, if we have testimony, witnesses testifying, there may be evidence introduced, why is that different from a trial? Probably the best way for me to try to explain it, and this is what I do with my clients, is if you had a scale that started from 0 to 100, 100 being the highest, somewhere up there, 90 plus, is beyond a reasonable doubt. At a preliminary hearing, you're at the exact opposite end of the scale, something more than 0 that shows two things. One, there's been a violation of law. Two, there's reasonable probable cause to believe you're the one that committed that crime. Once a judge finds those two things, you are held to answer. That is technical term, is held to answer, to go on, in the felony case, to a jury trial, because the court has found that there's been some violation, some probable cause to believe you committed that crime, and you're going to go to trial, and of course, unless the case resolves. But as you said, the court can dismiss charges, but the court can also add charges.
Right. And the district attorney can file charges greater than they did in the first place. I have an interesting question, though, here. And one thing, whether it be a misdemeanor or a felony, and because in misdemeanors, we know trials are set down the road, or pre-hearings are set before trials, and then a preliminary hearing is set within a certain time limit. But what does an individual do when they find themselves in jail and they're in custody and they want to get out?
It's a real hard thing for lawyers to have to work through, because your client's in custody. They don't like to be there, obviously, and they know that they've got a right to a preliminary hearing within 10 court days, and they want to rush. But for lawyers, oftentimes, we're wanting to slow it down to make sure we get all of the reports, have an opportunity to look at the evidence, perhaps interview witnesses. We want to slow it down so that we can make sure that we adequately and appropriately represent our client. And often it's spending the time with the client to explain, this is what's going on, this is why, and we ask them to waive time. This is another technical term. When you're in court and they show you your rights, it tells you what the time frames are, that certain things must happen. Unless you waive time, the court has no choice but to stick by the time frame that's set out by the law. Now, there are very limited situations, but there are some times when the court can actually, over your objection, find that there's good cause to exceed the statutory maximums. But that doesn't happen very often.
No, I've seen that one or two times, but that's pretty rare. But there is actually a process to try to get your client out of custody. Prior to these hearings, you could ask the judge for an OR, and sometimes I've actually seen people OR that aren't even represented. How did that happen?
And an OR is?
Released on your own recognizance. I should stop using this and start using real words.
Again, that's technical language we tend to use. We refer to things sometimes by numbers, not by names that are common, like DUI. Most everybody knows what a DUI is, driving under the influence of alcohol. We still hear 502. 502 is a code section for driving under the influence of alcohol that probably was superseded in the 1950s. The subsequent law was 23-102. It's now 23-152. Now, those code sections relate back to the vehicle code, but we still today hear 502, or I was 86th out of a bar or something. We all have the shortcut, but OR is own recognizance. Again, it is in the Constitution that everybody's entitled to reasonable bail. A very specialized area that, again, you can almost spend an hour just talking about bail. Typically, on infractions, you can't go to jail. Misdemeanors, you have a statutory right to bail. But there can be situations that the reasonable bail, given the facts of your case, may be a little high. Certainly in felonies, it's not unusual to see $50,000 or $100,000 as a bail schedule. Every court sets a bail schedule for different types of crimes. As they're elevated, the higher the bail goes. The court sets a statutory bail. But that's a whole topic in and of itself.
Let's say somebody goes into court on one of these arraignments. I've seen it all the time as I'm sitting there waiting for my case to get called. Somebody comes in and gets arraigned, and they want to explain the whole situation. There is a thing that a very important right that's called the right to remain silent. What do you think about that at that point in time?
Well, practicing criminal law, I think it's a great right. The right to remain silent we all have. The laws have changed over the years. When I was in law enforcement, which preceded my attorney days, we were taught at that time, because the Miranda decision, which many of you have heard about, had just come out, you couldn't talk to anybody without advising them of their rights, even if they were a witness. Today, that law has been lessened. We hear DUIs a lot of time. I got stopped. The officer asked me these questions. He arrested me. He never advised me of my rights. Why? Because he didn't have to. The California law says in that situation, he doesn't have to advise you of your rights. So if you're ever contacted by law enforcement, certainly you have a right to say, I'm not going to answer any of your questions. I want an attorney present. The officer doesn't have to stop and go get an attorney on the spot. If he's got enough to arrest you, he's probably going to arrest you. But we find, certainly as in your practice as well as criminal law, the more you say, the more it's going to come back and bite you at some point. If you've been contacted by law enforcement, they want you to come in and give some type of statement. Now, that's assuming you're not just a witness. You know that they're looking at you for a particular reason. Make a call to an attorney. In the criminal law field, you'll find that is one of the few areas where an attorney will actually talk to you on the phone and give you some guidance. They may not in other areas of law, but virtually every attorney I know will tell you, don't talk without talking to an attorney first, and don't talk to law enforcement.
One thing, the average person cannot record a conversation of another person without them knowing about it. That's actually a crime in itself. But when a citizen is contacted by law enforcement and is in an investigative setting, you're being recorded, aren't you?
Not always.
Not always.
But the officer can record you legally without letting you know that he is recording you. And he can even deny, now there are female officers too, so she can deny
That's true.
that you're being recorded. They don't have to tell you the truth. A lot of times I'll hear, well, the officer lied to me. They can lie. There are case laws that says the officer can tell you almost anything. Now, we got to understand that while Bob and I do criminal law, we're not here attacking law enforcement. They absolutely serve a great purpose out there. They keep us safe in our homes, and
I depend
they
on
do have a purpose.
I depend on them every night I go home.
Absolutely. And it's changed over the years. I remember when I was a young person being raised here in Calaveras County, there may be one deputy for the entire county that probably went home at midnight and went to sleep. And it has changed. They're far more proactive today than they ever have been. The laws are there for us, whether it's a criminal law, and certainly we see laws that are there for the 1 or 2% that violate the laws, but it applies equally to all of us. Correct?
Yes, it does. It applies across the whole social spectrum. And that's one of the great things of the country we live in. Our court system. A lot of people say there's all these faults in it, but I've yet to see a better system in the world today. Particularly the jury system.
Yes. There are certainly other countries that have completely different laws. A lot of us have heard about stonings because somebody committed adultery or didn't wear particular clothing. And irrespective of what you may think about the laws in this state, we do have a right to vote. We do have an opportunity to change the laws. And that's why, in part, we're doing this program for you, the law and you. We hope to educate you more on the law. Thank you for being with us.